between the two, departments. They fit into each other. I'm mentioning these two departments primarily because they are central to giving effect to Section 25 of the Constitution. Now, the departments are now here because if this bill was emanating from the department, Department of Land Affairs or Department of Public Works, which one? One of the two. This bill that we're talking about, the Constitutional 18th Amendment Bill, it will be accompanied by a detailed memorandum setting out the purpose, the background, and the weaknesses that these proposed amendments seek to address. Or if you want, the mischief that these proposed amendments seek to address. But because it doesn't come from any of the departments, it comes from the resolutions of Parliament. So we don't have that technical aspect, the technical nuances, and that would have accompanied the memorandum and the presentation that will be made before the portfolio committee. What is it that, how this process or this bill will enhance the performance of the Department of Public Works, how it will enhance the performance of the Department of Land Affairs? We have been to public hearings, and people mentioned a number of challenges, a number of gaps, but the presence of the department will, without getting into the details of what those issues are, but will just tell us how this will help them address all the issues that people have just spoken about, and which have actually delayed the issue of land transformation in our country. So today it's nothing but just to hear how the department looks at it technically, because what we have flowing from the resolution and flowing from the CRC report are just the aspirations, but the technical aspect of it, we are yet to hear from the two departments. It is in that context that today we thought we should invite them just to give us how they look at it, insofar as they are entrusted with the responsibility of giving effect to Section 25. I thought, Chair, that summarizes the process and my understanding of what transpired at the last meeting of this ad hoc committee. Thank you so much.
Honorable Kava, that summary is in line with my understanding of the mandate. Now, is there anybody who has a problem with that summary?
Yes, I do.
Who are you?
Chairperson, my hand is up.
Yes, Chairperson, yes. My hand first. You will see.
Dr. Mulder, please.
Thank you. May I react? Thank you, Chairperson. Now, I would like to thank Honorable Kaba for his interpretation and for the feedback that he gave us. I've got two specific points. The first one is he made the statement when he refers to the Constitutional Review Committee that there was an overwhelming mandate. Now, we all know that that is in dispute. We all know that there is a legal challenge, and there will be some more challenges, most likely with regard to the mandate, in the sense, and you remember correctly, and we all do, that the almost 500 or more than 500,000 written submissions was not taken into account. So that's in dispute. So I just want to make that point first of all. Secondly, in his report, basically, he completely forgot that there was another ad hoc committee. There was another ad hoc committee that dealt with this by coincidence under the chairpersonship of now the minister, who was then not the minister. And they also had a mandate, and they had to complete that process before the 2019 election. And we all recall that they did not succeed in doing that. So, but he didn't touch on that specific point. When it comes to the two departments specifically, I think we should be very careful. I don't think it's our mandate to interact with the departments, to hear from them all their technical and practical problems in terms of what they are expected to do. That's not our mandate. Our mandate is in terms of what we need to do, and therefore a specific bill was drafted, the 18th Amendment. And I think the only thing that technically we could hear in terms of the rules, because I'm talking about the rules that we have mentioned the last time that we should interact with the departments, is we should engage with those two departments to get their comments on the proposed amendment bill. I don't think it's our task or even their task to brief us in detail in terms of all their problems in terms of land reform and whether they've got problems and whether there's corruption. It's really not our mandate. Thank you, sir.
Thank you very much. The other hand, who is that?
That was mine, Chairperson.
Yes, proceed.
Thank you very much. Chairperson, I would firstly want to inquire in terms of procedural matters, at which meeting, because you said that the Honourable Kaba was given a mandate to do certain things, and I would just like to know at which meeting was that resolved and exactly what those instructions were, because I am not aware of it. And secondly, clearly, to provide the mandate for this committee and explain it is the responsibility of the chairperson and not a member from a political party serving on this committee. So that is the interpretation of a member of this committee. So I am very concerned that we are moving in a direction where this is quite unprocedural. So if you could perhaps just give clarity exactly what was the instructions given to the Honourable Zaba and at which meeting was that resolved by this full committee. Thank you.
Honourable Josie.
Thanks, Chairperson. I quite frankly am not aware of any rule of Parliament which would say that we shouldn't listen to the departments and what challenges they have in relation to this important problem of land reform. I think we must not be misled. If people are saying there are rules, they must quote those rules. You don't just say there's a rule and then a rule exists. Which rule says there's no such a rule? I'm not sure. And if a person is disputing that we hear departments in relation to their inability to have distributed the land successfully, they must say that, they must not invoke non-existing rules. That is consistent with the presentations we've been having here. People have been at liberty to say, because of challenge X, the constitution shouldn't be amended. Because of this and that, the constitution shouldn't be amended. We didn't stop them, majority of which were representing white organizations, or predominantly white organizations, property owners. They've been giving a critique about the fact that, no, the impediments for land reform, of the impediments for land redistribution lie not with the legislation, but with the inabilities of government. It seems to me only fair to hear what government is going to say to that. And there is no rule. I mean, that's absolute nonsense. There's actually no rule that stops us from hearing. So that we are able to intelligently arrive at a proper formulation, we must be informed by such things.
Thank you, Honourable.
I find that submission rather irrelevant. Thank you.
Thank you. I'll take only the last two hands, three. Honourable Shibambo, Honourable Hon, Honourable Lesuma, and then I'll make a ruling because I think we are going out of the way now. Proceed.
Thank you, Chair. So just want to remind those that are conveniently forgetting that in the last meeting, the basis upon which we said the departments of public works and land reform and agriculture must stop the presentations was that so that they can come and broaden the type of presentations that they give to this committee. That resolution was taken, so no one must claim oblivion to that. It's opportunistic to do so. So it's only appropriate that prior to finalizing the phrasing in terms of the constitutional amendment, we should get the departments to respond to so many allegations that are made against them, but also to understand some of the difficulties that they could have encountered in the process of dealing with land and property in general when it refers to public works. So let us proceed and listen to what we agreed in the last meeting we must listen to. So no one must ever mislead this committee that we didn't mandate this process. It was duly mandated in terms of what we expect to be presented today. So let us proceed in that way. And of course, Chair, just in conclusion, you must take consideration that there is an ongoing attempt to filibuster the process and try to frustrate it. So we must always be alert to the right-wing elements that are trying to divert this attention.
Honorable, thank you, Honorable Shibambo. Honorable Hon, Honorable Lesoma will be the last.
Thank you, Chair, and good morning to all colleagues. Yeah, Chair, my input is this. We are a committee of Parliament, and while it's obviously, I think, within our purview to listen to departments that deal primarily with land and possibly even expropriation, we must then simultaneously not turn a blind eye, I think, as others have already indicated, to the products of other processes of Parliament. And so, for example, then one has to ask the question, what then about also asking those who dealt with the so-called high-level panel report, former President Mutlantle and his team. It is a report which I've just now again found on the website of Parliament. So it is, I think, a strange, at best, approach to say that we will only engage now with the departments and source their views, whilst there's the product of very specific other activities of Parliament in the past, which is also relevant if we are looking into why land reform has failed up to now. Thanks.
Thank you, Honorable Hon. The last hand, Honorable Suma. We have
yeah. Good morning, colleagues, and thank you very much, Honorable Chair, for the opportunity. My humble appeal, Chair, the other questions that are not intending to listen to the department, I will suggest that we deal with them at the end. Otherwise, we'll spend an hour discussing things that are not going to assist in terms of the department, in terms of the mandate that we have been mandated.
And the host kindly mute.
Okay, proceed, Honorable.
No, so I was saying that my humble appeal is that we proceed, Chair. You have also, you assisted in reminding us that let's stick to our lane and leave other portfolio committees sticking in their lanes. Let's proceed. The rest we can discuss it later after the presentation and the purpose of today. Thank you.
Thank you. Honorable members, you will recall that Honorable Kaba was requested by this committee to help the administration finalize the revised document. And I asked him to input not because of the party he comes from, but because he has an institutional memory of where we are. And he demonstrated that before this committee, and this committee unanimously asked him to help. And I think as the chair, I have the discretion to take that decision. But I also want to say that he has ably summarized our mandate, and I'm going to request Honorable Kaba that you do a 2-pager summarizing our mandate, and we will circulate it so that going forward, we don't have to be discussing unnecessary things. For instance, that people say they can't listen to the department. The department is invited in terms of a rule of parliament. They have the right to be here. They have the right to brief us. And as I said in the beginning, we have several processes, and these processes are interrelated, as Comrade Kawa correctly said. So it's important, therefore, that no other stakeholder is left behind. And I also want to end by saying that we must apologize to Comrade, to our Honorable Didiza, because this confusion that begins to emerge confirms that we sometimes forget our mandate, and Honorable Kawa has correctly reminded us, and we are going to move along what he has said. He will give us a 2-pager summarizing the mandate that in future we must focus to the core business of this committee. Honorable Didiza, I will allow you to do the briefing, and at the end of that, we will release you, because you have not come here for interrogation. We don't have oversight right over your committee. So we appreciate the fact that you agreed to come and brief us. Thank you. Proceed.
Chairperson, honorable members of the committee, senior officials present, ladies and gentlemen, I would like to appreciate the opportunity that we've been given by the committee to actually come and present before you. In my opening remarks, I'll try just to be broader to capture some of the issues that have been raised by members, which arose indeed in the presentation when you were doing your oral, receiving oral submission rather, as well as receiving comments from the public as you went around the country. Indeed, some of those issues relate to the implementation of land reform and what challenges communities have faced. And similarly, as other members have so indicated, they will inform us best on what, from the department side, may have been some of the constraints in our view that arise, particularly on the legislative framework, which we hope that through this process will actually unblock. Chairperson, I just want to take us briefly back on where the issues about land reform emanate from. We would recall that the interim constitution, as the negotiators were dealing with that process, acknowledged the need of land reform in our country as a mechanism that will address the imbalances of the past, where land dispossession had actually made some of our people landless. As part of the constitution-making process, land reform was therefore embedded as part of the Bill of Rights, which gives every citizen the right to property. But given our history of dispossession, the drafters of the Constitution ensured that in order to In 1995, the Restitution of Land Rights Act was promulgated in order to ensure that those who were forcibly removed from their land since 1913 will receive a form of redress for the rights lost at the time. I know that this matter of the cutoff date was debated heavily then and even during the making of the final constitution in 1996. However, this is what we ended up with. The form of redress, as indicated in the 1995 Restitution of Land Rights Act, includes land restoration where such is possible, alternative land where original land may no more be available, and financial compensation. The institutional arrangements provided for in law was the setting up of the Commission of the Restitution of Land Rights as well as the Land Claims Court, which would adjudicate where such disputes might emanate on how land the restitution is undertaken. But also it allows for a process where some communities could actually approach the court directly for the redress of their restitution processes. The policy framework on land redistribution was also put in place by amending some of existing legislation, as well as drafting new legislation that would provide for the state to redistribute land in order to address land inequality, address the human settlement challenge, livelihoods, as well as agrarian reform. Tenure reform was also identified in terms of our policy as an important area of reform given the dual nature of the tenurial system in our country. Let me identify what are the challenges that were faced that have impacted in the pace of land reform in the past 27 years. The Reconstruction and Development Program, as you might recall, members, actually envisaged that the state in the first 5 years will redistribute about 30 million hectares of agricultural land to those who were historically disenfranchised. This instrument, the instruments, however, both in policy and legislation, were inadequate to give effect to this ideal. If I were just to make an example on land restitution, for instance, after the promulgation of the legislation in 1995, the Land Claims Court had to be set up, and it was operational since 1996. And as we know, without full-time judges except the judge president. The claimant communities also, as well as individuals, had to lodge claims from 1995 until 1998, just a year before the end of the 5 years, which then indicates what already the difficulties were in terms of the policy and the legislative framework. The commission and the administrative support to the commission had also to be put in place in order to give effect to this injunction of the legislation. The need to undertake research in order to validate the claims took longer than envisaged. Again, the acquisition strategy was through willing buyer, willing seller principle. And as we know, the application of the factors in Section 25 of the Constitution, particularly Section 25(3) of the Constitution, indicates how the state can determine just and equitable compensation, became difficult in two aspects which I would highlight. One, if you look at those factors as highlighted in Section 25(3), you require archival records which will give the history of acquisition. The Constitution drafters, in my view, assumed that all land was acquired when we all know that after the promulgation of the 1913 Native Land Act, those who were the beneficiaries were actually allocated land. There was no form of acquisition that one can talk about in that instance. Subsequently, owners and their dependents may have later sold the land, we agree, and therefore, when determining the history of acquisition of property, the difficulty is at what stage do you start to determine the history of acquisition? And I think this is one of the areas which I think in the amendment of Section 25, as honorable members, in my view, will have to reflect and ask ourselves, to what extent does these factors as provided for in Section 25(3) in particular assist or actually limits the capacity of the state to implement land reform? Secondly, the subsidy that the state had given, as it is provided again in subsection 3, that we need to look at the subsidy that the state had given in order to actually defray the cost of that when calculating just and equitable, became a challenge in that if you look at the subsidies that were given, majority of them were not directly monetary in certain instances. It was either soft loans, or in certain instances, it were subsidies that will enable farmers to put up certain infrastructure, and also on collective marketing, such as the agricultural marketing boards, which were there. And therefore, to distill an individual the benefit of that subsidy was not an easy thing to actually determine. Just an equitable form of valuation, it again was another problem, given that there were no variables that were developed in order to aid professional valuers to utilize in order to determine what value is just and equitable. And these are some of the issues even today bedevil the Office of the Valuer General in determining just and equitable, where a number of litigation had actually been put against the department on how the Office of the Valuer General has actually determined their prices as they would actually make the offer to purchase. Therefore, these factors, in my view, contributed in not being able to adequately assist the state to negotiate fair value for land that was and is still acquired in the open market, compounded by the fact actually that the state is the sole buyer in the market. The lack of coordination also across government also made it difficult for beneficiaries of land reform to create productive assets on the land that they might have received. This is one of the factors that was actually highlighted both in the high-level panel report chaired by President Motlanthe, as well as the Presidential Advisory Committee on Agriculture and Land Reform that was actually chaired by the late Dr. Vuyo Mahlatsi. It is these issues also of coordination that made government to set up the Interministerial Committee on Land and Agriculture, which is chaired by the Deputy President, in order to bring together across government all of those departments that will be impacted upon land reform, so that in the way in which we address land reform, there is coordination, at least from the government side. The other issue related to post-settlement support, which all of us have agreed have been minimal, at best disjointed between spheres of government. The choice is also exercised by individual families and communities. So most of the claimants opting for financial compensation as opposed to land restoration, as all of us would have wanted. Land redistribution has also been skewed towards those who want land for agriculture, as opposed to addressing issues of human settlement and other land-related needs. It therefore had a rural bias that enabled the land inequality in the urban and peri-urban centers. The weaknesses in land administration system has also been exposed, particularly where one looks at the allocation of land through a leasehold. And in certain instances, it is this area of work that have indicated a lot of malfeasance that has happened at local level. But at the same time, it is this area which is exposing or have exposed also in the past the weaknesses in the department's capacity to be able to manage this area properly. The change of programs also often has resulted in confusion on how the state support those who require land, in particular farming land. You will note, Chair, that there had been various programs that had been developed by government as interventions in assisting land redistribution. For instance, some of those programs, such as the share equity scheme, had not resulted to what we had desired. But also, if you look at certain interventions, such as the extension of security of tenure of Land Tenure Act, had actually dealt with the issue of land evictions of farm workers in particular, more regulating the eviction rather than addressing, in essence, the land tenure of those farm workers. Again, the issue of labor tenants and the Labor Tenants Act has in some way tried to ameliorate the challenge, but not entirely. That's why some of those challenges are bedeviling us even to this day. The weakened capacity in the administration has also contributed to the slow pace on land reform. I'm raising some of these challenges that relate to the capacity of the state chairperson, even though not as detailed as you might have wished. It is some of these challenges, as we all appreciate, which have been reflected on the high-level panel on the assessment of key legislation and acceleration of fundamental change, as well as the Presidential Land Advisory Committee that was set up. But what has been the interventions? Because while the problem have been highlighted, it does not mean these have not been attended to. Maybe not all of them at the same time. But I just want to highlight some of the things that have been done to ensure that from the government side, we are also alive to the challenges that have been raised. One, for coordination, the Interministerial Committee, as I've said, has actually been set up and has been continuing at least in the last term of the 5th administration and was resuscitated again in the 6th administration. The beneficiary selection and allocation policy has actually been approved by Cabinet, and it was also circulated for public comment because it addresses the issue that was raised in both these reports of lack of transparency on how people can actually receive land from the state. What is the policy for allocation? What is the policy for beneficiary selection? The other is the land donations policy, which also has been approved, because one of the issues that were raised in the report of the Presidential Advisory Committee was that those people who are landowners who would want to donate land, there is no framework which indicate how they may do so. So the land donation policy has actually been finalized. The reconfiguration of the department also, in my view, has been another intervention to ensure that there is alignment and coordination. Building the capacity within the department, which is issue that has been raised, is actually being done through filling critical posts, and we're continuing with that, particularly at this stage. The building of the institutional capacity for land administration is a matter that we are dealing with at the moment because, again, this issue has arisen on both reports. The establishment of the Land and Agrarian Agency to assist in the fast-tracking of post-settlement to those who have received land is another instrument that government has actually put in place, or is rather putting in place. The building policy and legislative frameworks to ensure that indeed one of the things that we address, which is in section 25, 6, if I'm right, that gives the state the opportunity to actually develop law of general application that will ensure that we fast-track land reform is what we are busy with at this point in time. Also, we are, in terms of the legislative framework, addressing the issue of the dual land tenure system. We have been engaging with our portfolio committee in that regard. We are also fortifying post-settlement support interventions through financial and non-financial intervention, as well as building the capacity in terms of the extension advisory services, which have been highlighted by the Minister of Finance in this year's budget, is again another intervention to ensure that we beef the capacity of the state. How will then the amendment of section 25, in my view, Chairperson, assist us to actually unblock some of the difficulties? As the National Assembly and the NCOP agreed, we need to ensure that we give clarity on what is ambiguous in the Constitution. If one look at the factors, for instance, that I've highlighted to, I think as legislators look at these sections of section 25 will enable us to remove some of the challenges. Re-looking at the applicability of the factors that must be taken into consideration when determining compensation as reflected in section 25, I think would assist us very much, Chair. Giving further elaboration on section 25.2, which already talks about expropriation, that such depending on a range of factors may enable the state not to pay for compensation, I think will actually elaborate that section of 25 subsection 2. Giving further clarity on the role of the courts in expropriation matters, particularly in determining compensation. Again, it's one area that would like this committee, as it does its work in the amendment of the section 25 of the Constitution, really look at whether it actually bringing the courts up front does it actually assist the executive in executing the role that they must in respect to expropriation matters? Providing guidance on the amendment of Expropriation Act of 1975, which I know, Chairperson, is being dealt with by another portfolio committee, but I think this committee, which looks at the amendment of the Section 25, would actually assist that committee as well in giving guidance in how they will amend going forward. Chair, I thought this would be my opening remarks before then allowing the department to give the technical presentation on the things that we think as a department will assist us in the amendment of Section 25. Thank you very much, Chairperson and members.
I think the chair must have to unmute himself.
Honorable Minister, I'm saying that these were not just opening remarks, but you have really empowered us, because some of the negative things that we tend to say or do is because of lack of information. Now you have provided us with enough information, and your presentation is now on record, so nobody can now come with stories, because we all know where we stand, where the challenges are, where the interventions are, what your expectations are from this committee. And thank you very much, Honorable Minister. And I don't think you have to stay. If you run out of time, you have done your part. The technical work will be done by your department. And thank you very much once more. Yes.
Now, I would think that if the minister is still available, it would be great that members get to ask questions, clarity, and maybe contextual issues that have to be elaborated.
No.
That is because
I accept that. All I'm saying is that I announced at the beginning that she has to be elsewhere, and bear in mind also that we gave her short notice to be here, and she respected the committee and she's here. But for as long as she's available, she will do that. Thank you very much. Over to the department.
Chair, through you, Chair, I would request that maybe if members want to ask now, because the Interministerial Committee on Land is starting at 10:30, so it may limit the time in which I may be available to the committee.
Or maybe we should first allow them to put those questions of clarity to you, and then we can take the other reports later. Yeah.
Yes.
It's really questions of clarity and not debating with the minister, because we don't oversee her. Thank you. Any hands? Honorable Horn.
Yes, thank you, Chair. And in the interest of time, I'll try and be quick. Minister, the high-level panel report, to which you also referred now, made specific mention that the enabling legislative framework to achieve the constitutional ideal of equitable access to land is, well, not sufficient, or rather missing. So have your department done anything to fix that? While this one thing which you say can assist land reform, which is the change in the constitution, is taking place, or will we sit with a situation that that legislative framework will still be absent once the constitution is amended?
Thank you, Honorable Horn. Honorable Shibambo.
No, thanks, Chair. I want the minister to talk to the process which the department engaged in last year on the advert to lease state agricultural land, in terms of what is the model there, and if that is not the much more sustainable and better model where the state retains custodianship of the land and lets it accessible to those that wants to engage in agriculture. Instead of the freehold system, when you give people freehold, they dispose it to those who currently own it before, or they use it as collateral to borrow very little amounts of money from banks, and later on they're dispossessed of the same land parcel. I would want, perhaps as part of the reflections, to get an overview of the state, the land which the state has leased to different agricultural practitioners, so that we are able to locate some of the arguments that we'll make later on in a clearer context. Thanks, Chair.
Thank you, Honorable Shibambo. Any other hand? I don't see any other hand. I guess the presentation was clearer than anything else. Honorable Minister, if you can take those two and then we'll release you.
Thank you very much, Honorable Chairperson, and also thanks to the members who have raised the questions for clarity. In respect of the law for general application, as it's indicated both in the Motlanthe report as well as in the Constitution, as I've indicated that I have said this was the weakness that we had not done that legislation, but we have actually, in response, as part of our response to the panel report, which itself had identified that, which is the advisory panel. It's one of the legal frameworks that we are putting in place. So the Portfolio Committee on Agriculture and Land, as part of its legislative program, will receive one of those legislation. So I can say, Honorable Horn, that we won't have a vacuum even when we amend this section 25 to, to leave that legislation not being developed. You would recall that actually 2 of the commission members of the Motlanthe Commission, they had even had a draft legislation, but Parliament acknowledged that it was not their mandate to come up with the draft legislation. That had to actually be processed either by the Committee of Parliament or by the department, or even a private member's bill, for instance. On the issue raised by Honorable Shibambo, on what is my view about the process that we started last year in terms of the state releasing the land that is in his hands for lease by those who would want to farm productively. I must say that for me, I think one of the issues that we need to look at when we look at tenure reform in South Africa is to accept that we will need to have multiplicity of a tenural system, which allows for freehold, which allow for leasehold, or what is known in other jurisdictions as user-fried right, and what is also known as a customary. Because if you look at customary tenure, for instance, in South Africa, it has actually lived and has been resilient over time in protecting communities' land rights. What has been the challenge is that that has not been codified. So you would have the state being a trustee of traditional land in South Africa. Actually, on a daily basis, traditional leaders and their communities manage and administer that land with their rules that are actually translated from generation to generation. And I think for me, looking at the African continent and other jurisdictions, there is nothing wrong in actually ensuring that customary land tenure can be resilient. We've actually seen in Tsendane in Eastern Cape, where one of the private sector companies, Wiphold, which is actually women-owned company, investing their land in promoting agriculture, working with those rural communities in what, quote unquote, has been said by financial institutions is not bankable, is not secure. And it has proven differently. That area now is actually having one of its silos for storage. And I'm sure if they want to extend and have a processing plant, they will do so. But what we need is to codify and ensure that our tenural system that accommodates customary tenure is in par with other forms of legislation. And user-friend right, which allows for leasehold, and I must say what the benefits are, Honorable Shibambo, in my view, is that your 30-year leasehold is kind of like a financial lease. It allows the person to actually get and borrow money to be able to invest in his or her production, but also it removes the burden of mortgage in the instance of entry, particularly for your young entrepreneurs into the sector. But it does not negate the fact that other people may want to have title on their land and hold it in a freehold system. So for me, I think it's more the multiplicity of tenural system that we must obtain and have all of them codified in our system. I'm not sure whether that has been helpful.
Honorable Shibambo, I guess you have also been empowered like me, so can we move on? Okay, Honorable Minister.
No, I think we're fine.
Okay, yes.
And thanks for the advice that we must delete subsection 3, we'll do so.
Okay. Yeah. Honorable Minister, who is going to address us now on technical issues?
Well, the team in the department will do so, Chairperson, and I indeed would like to apologize to the members that I will have to step out of the meeting to attend the Interministerial Committee, which starts now in 6 minutes. But I have enjoyed the little time, and I'm sure if I finish early, I'll try and log in and see whether we're still continuing with the engagements. Thank you very much, Chair.
So, Minister, I can also assure you, we are going to keep proper minutes and also circulate the documents and the inputs so that in future, there will be no confusion that may create problems for you and other ministers and deputy ministers. Thank you very much. Let's proceed. From the department, Advocate Bonano. Advocate Romano.
Yes, Chair.
Yeah.
I'm not sure who's leading us from the department. Mr. Sibifelo, can you indicate who's leading your team?
Morning, Chair, honorable members and colleagues. Advocate Ramasala will be leading the presentation. I will upload it from the side. Thanks.
Okay, proceed.
Good morning, Honorable Chair and honorable members. It may be that the committee doesn't want to be burdened with repetitions. The minister, as committee members will notice from our presentation, has covered almost all the areas to highlight. In fact, in some instances, she has provided more comprehensive information than is in the presentation. But if the committee so wishes, we can go through the presentation. In fact, in some instances, on the challenges and the solutions, she has provided more information than we actually have in the presentation. But we can proceed with the presentation. Honorable Chair, honorable members, the members who notice from the presentation outline, it basically covers the land reform that the minister has spoken to. Basically, the three aspects of it: restitution, redistribution, and land tenure. We also touch on farm dwellers as well as labor tenants. In the main, in relation to the duty of the state to acquire land to provide in these different instances. Starting with the mandate of the committee, we just stated that to assure the committee that we understand the committee's mandate. And then with regard to land reform, with regard to restitution, Chair, we make the point that the minister has already made, that with regard to restitution that starts from the Constitution, the need for it, and subsequently with the passing of the Restitution of Land Rights Act, and with the subsequent amendment of that act to provide for expropriation in terms of that act, that the expropriation must be in accordance with the Constitution. It still refers to that the restitution must occur in terms of the current Expropriation Act, as well as the Promotion of Administrative Justice Act. So with regard to the challenges, they remain the same. The challenges of expropriation that the minister has highlighted obtained still with regard to the restitution process, and then and also the coming to the issue of redistribution after the period within which claims could be lodged has expired, which was in 1998. There was an attempt to try and extend the claims period, but unfortunately the act that sought to do that was declared unconstitutional. So as things stand currently, claims can no longer be lodged, and that's why the department has approached the matter from a redistribution point of view, with an attempt to try and make ensure access to land on an equitable basis, and then also the issue of land tenure, as the minister has indicated, dual land tenure. We have mostly urban land tenure, which is currently regulated by the Act of Land Tenure Rights, in terms of which persons who are currently holding certain land rights that are described in that act have the authority to have the right to have those rights converted into ownership in the form of title deeds. Unfortunately, one of the sections in terms of that act was challenged in the Constitutional Court on the basis that it discriminated against women, because it was based on an old proclamation that stated that the deeds of grants could only be issued in male persons' names. And then an amendment bill to correct that is currently before Parliament. And then as soon as the Amendment Act is passed, that process will continue for persons to convert the deeds of grants into title deeds. With regard to communal land, as the minister has indicated, most of it is still regulated in terms of pre-1994 legislation. And members would also be aware that in 2004, the Communal Land Rights Act was passed, which sought to regulate communal land in general. But unfortunately, the act was also declared unconstitutional. And since then, the department is busy. We have already developed a draft bill that will deal with communal land in general, that we hope will be tabled in Parliament during the course of this year. As the minister has indicated, it is one of the bills that is receiving extensive consultation, in particular with traditional authorities, because it has a direct bearing in terms of how they are going to be involved in communal land regulation administration. Coming to farm dwellers, which has also been a challenge, the extension of security of Kenya Act that deals with that. Although it provides for the expropriation of property for the development of settlements for farm dwellers, that has not been much emphasis in terms of precisely because of the acquisition property challenges that are related to expropriation. Emphasis, as the minister has indicated, has been around the issue of dealing with evictions, to ensure that evictions can only be lawful. On labor tenants, also, there was a process in terms of the Labor Tenants Act that persons who were on the farms at a given time would be entitled to apply to the department to have the piece of land that they occupied awarded to them. That is the process that was met with legal challenges at some point. But as things stand now, that process is ongoing. The court has appointed some kind of a special master to assist the department dealing with those applications. Basically, that's the presentation in brief. With regard to the amendment bill, as the minister has indicated, we welcome the 18th amendment bill. We as state law advisors in the department, we do not share the view that it is implied in the constitution to have expropriation without compensation. We believe that making that clear would assist the department in engaging in acquisition, and then also looking at the circumstances that are listed in section 25.3, which has been a challenge, as we have indicated in our presentation. It is an area where we are currently engaging with the Office of the Viewer General to assist us with explaining or developing the principles around the justification and how we arrive at those circumstances. But it would assist that if the committee was to look at those circumstances and then maybe do away or give more clarity in terms of how those circumstances have to be interpreted. That will also assist the courts as and when disputes arise in terms of interpreting those factors, which will ultimately assist in the determination of what the Constitution requires as just and equitable compensation. And lastly, with regard to the amendment bill, the issue around the role of the courts as provided for in the Constitutional 18th Amendment Bill, where the court, in addition to being involved upfront in the determination of compensation, the court is also involved in determining whether particular circumstances exist that would necessitate expropriation without or with nil compensation. We believe that the involvement of the courts in those two stages, which in our view are the realm of the executive, would make it difficult that when disputes arise at that level, because the court would have already been involved in the determination of those policy or legislation implementation, the court would have already tainted themselves that they will find it difficult to at the end of the day to be the adjudicator of the dispute that would have arisen. So our recommendation would be that we remove the courts from playing a role at that level, and that the courts only deal with disputes when the disputes are referred to the courts. That Chair, honourable members, our presentation. We are once more thankful for the opportunity to share with the committee our views on this particular matter. Thank you very much, Chair.
Honorable Chair, the presenter have concluded.
Hello, Honorable Lesoma.
No, I was saying, Chair, the presenter have concluded. It's just because I couldn't hear your voice. My apology.
Oh, okay. No, I was muted. I'm very sorry. I'm saying that we should. I'm apologizing on behalf of the committee about the confusion last time, because it was not clear as to what we expected, and now after we have clarified what we expected, I think both the Minister and Advocate Ramasala have indicated clearly what they expect of us. And I think they've also empowered us as we move on, because going forward, we are going to be dealing with the draft bill and not peripheral matters. So I hope Advocate and the Minister will accept our apology, but we have done very, very well, and we have empowered all of us, and you are well excused. Unless there's no hand for clarity, so I guess everybody agrees with me that we have empowered and clarified us. Thank you very much. Advocate Ramano. Advocate Ramano.
Yes, Chair, the next presentation will be from Legal Services.
Oh, yes. Who is presenting from there?
I'm presenting, Chair.
Hello, Advocate Hali. I haven't seen you for long.
Yeah, long time no see. Yes, Advocate Romano, Mr. Romano, can I please have share screen access? Is my screen being shared? I'll just wait for him to set that up, and let me just do a bit of an introduction. Honourable members, as you know, the oral submission spanned over a period of 3 days, and there was a great deal of content received by those presenters. I'll try and summarize and be brief as possible, but I cannot deviate from the crux of the legal issues, as I'm sure members will appreciate. The presentation will outline the various legal themes presented during those oral presentations. And to summarize, there were 9 focal areas or 9 focal themes that were raised by various presenters. One being whether it was implicit in Section 25 that the amount of compensation may be null. 2, whether the amendment exceeded this committee's mandate, and whether the amendment, number 3, was whether the amendment was unconstitutional. Number 4 was whether the term without compensation should be used in the amendment. 5 was whether the amendment should consider land and its improvements. Number 6 was obviously the greatly debated role of the courts. Number 7 is whether the circumstances should be included in the amendment. Number 8 is whether the amendment flouts international laws. And lastly, number 9 is the differences between the expropriation bill and the amendment. The Constitutional Legal Services has responded to the legal issues in blue in my presentation. So for members, that is what our response is. And throughout the oral submissions, there was a number of policy matters that were raised. We have not.
A point of order, Chair.
Hello, who's speaking?
A point of order, Chair. Honorable Papama.
Yes, proceed.
Is the presenter going to put up her presentation? I'm sorry, I didn't catch that part.
She said so.
I was hoping that I would have share screen access.
Advocate Hali, hold on. She
Thank
said
you.
there,
Thank you. Sorry, I was just waiting for.
She said there from the outset and said she will do an introduction whilst waiting. So she's
Thank
going
you.
to...
Sorry, Chair, I missed that. My apologies.
No, nothing wrong. Proceed, Honorable Hali.
Not a problem. So we wish to also remind members that on the 4th of March, the Constitutional Legal Service Office has presented the committee with the responses to the written submissions. So these are our responses to the oral submissions. And on the 4th of March, we had highlighted to the committee that we believe that we should make a few amendments to the current version of our 18th constitutional amendment bill. And we suggested that there be a definition for land reform, i.e. linking it to subsection 8 of section 25. We also suggested that we clarify the role of the courts. We then suggested that the memorandum of objectives be corrected. And we also suggested that instructions should be sought in relation to removing improvements on land and further expanding, deleting, or retaining subsection 3A. Before I start, I want to remind members that we have not commented on any political or ideological debates, but only on the legal issues. Let's get started. So the first issue is it implicit in section 25 of the Constitution that the amount of compensation may be null? There appear to be varied opinions between some submitters, some saying that it's not implicit, some saying that yes, it's implicit. Sakhalikha did not agree that it was implicit, stating that expropriation without compensation is confiscation and that therefore it is incompatible with the Constitution. They also had the opinion that this amounted to public fraud or fraus legis facta. Whilst other organizations such as SA Property Owners Association, the Helen Suzman Foundation, Land and Accountability Research Center, and Agri-SA argued that there was no need to amend section 25 as it did not impede on land reform and the current wording of section 25 provides for expropriation with the amount of compensation is null. Our response to this is as follows. Yes, it is our understanding that expropriation where the amount of compensation may be null is implicit in section 25 of the Constitution. This flows from the right to just and equitable compensation, which is imbued in section 25(3) of the Constitution. And with regard to factors involved, just and equitable compensation may amount to an amount of null rand. Furthermore, section 25(8) provides that no section may impede the state from taking legislative measures to achieve land reform. Although expropriation, where the amount of compensation may be null, is permitted in the Constitution, in the current reading, the amendment is a policy decision to make that which is implicit, explicit. And that is what we are doing here, members. The second factor was whether the amendment exceeded the mandate of the committee. And AfriForum had mentioned in the oral submissions that the amendment exceeded the scope of the CRC, which was to clarify the state's current powers and only focused on land. Our response as legal services is that as an extension of the House, a committee must duly deliberate on the bill. Due deliberation may result in a need to extend a mandate. The committee will then apply to the House to approve such an extension of a mandate. However, it is our opinion as legal services that the Section 25 ad hoc committee stayed within the resolution taken by Parliament. The next factor or theme was that of the amendment being unconstitutional. And this would be prevalent amongst a number of presenters. Sakhalikha, as I mentioned previously, members will remember that Piet Leroux had said that compensation to be null is not implicit in the Constitution. And any change to that would include would change the constitutional substantially. He then also expressed that the amendment is an attempt to prevent expropriation where the amount of compensation may be null. He believed that the opinion was that it did not exist in South Africa and that we had been attempting to include this in the Constitution, and the state was therefore committing a fraudulent endeavor. Our response is that, firstly, we wish to highlight that Section 167(4)(d) of the Constitution says that only the Constitutional Court may decide on the constitutionality of an amendment to the Constitution. We also acknowledge the basic structure doctrine, and this was highlighted in Premier KwaZulu-Natal and others versus the President of South Africa. In that, there are certain fundamental features of or principles of a constitution, the basic fabric of a constitution, and that cannot be amended regardless of whether the Constitution expressly limits amendments or not. The basis of the basic structure doctrine is that the Constitution only grants powers to amend a constituted power and not the power to replace a constituted power. Where an amendment radically and fundamentally restructures and reorganizes the fundamental principles of a constitution, that amendment is not an amendment per se, but rather a replacement, and thus can be seen as unconstitutional. Justice Sachs, in the Executive Council of Western Cape Legislature versus President of the Republic of South Africa, expressed that certain features of a democracy which are not spelled out in the Constitution, but are inherent in its very nature, design, and purpose, and those features are so fundamental to the Constitution that even if Parliament followed a necessary amendment process, it could not change them. He then goes on to provide extreme examples, such as renewal of membership, i.e. eternal life of members, which would be against the fundamental principles of the whole of democracy. Therefore, to summarize, the question is, does this amendment undermine democracy itself, or does it destroy the Constitution? We do not believe that this amendment would change the basic structure of the Constitution, because private property rights and the right to compensation when property is expropriated by the state, it is imperative to the Constitution. However, if an amendment to the Constitution is framed strict with narrow language that would allow for expropriation where the amount of compensation may be nil in specific clearly defined instances, i.e. land reform, the amendment is not unconstitutional, and we do not believe that it is fraudulent. Lark, Ms. Nandi Boy of the Land Accountability Research Center expressed that by adding 3A to the Constitution, it would limit the power of the state. Our response is that, again, this is not against the basic structure doctrine. We submit that the amendment to the Constitution is unconstitutional only if it is against the basic structure doctrine. The expropriation bill, in any event, is an open list, so there is no limitation. And the words in the expropriation bill 12.3 are including but not limited to. The reason for this amendment is to give legal certainty on something that has been criticized as allowing for legal uncertainty. A few submitters had mentioned that the court in itself require guidance, and there is no clarity with regard to this issue. The Constitution has many enabling clauses that leads to the promulgation of national legislation that fills in where the Constitution gives the framework. However, whether to delete Section 3A or not is a policy decision that the committee must make. Which brings me to AfriForum. AfriForum had stated that the bill is in breach of Section 2, the supremacy of the Constitution, and also in breach of Section 36, the limitation clause, as the bill ignores the circumstances that must be considered when determining how much compensation will be paid, and Section 2 states that the Constitution is the supreme law and any law inconsistent with it is invalid. By ignoring the conditions set out by Section 25, this bill, in their opinion, was inconsistent with Section 25. Our response is that this is not a limitation of a right, and therefore Section 36 is not applicable. It is rather clearly defining the scope of that right. The bill is drafted on the basis that it is already implicit in the Constitution, and that in certain circumstances, it will be just and equitable for compensation to be an amount of nil rand. Subsections 3 of our Constitution and the new 3A make it clear that the requirements of subsection 2 and 3 remain relevant to determining whether compensation may be nil. Section 25 provides that provides factors that must be considered to determine what the amount of compensation should be. And in certain circumstances, it would be just and equitable for compensation to be an amount of nil rand. Further, in our opinion, we believe that it upholds the rule of law. And finally, that the bill makes an explicit that which is already implied in the current reading of Section 25. The bill also has a rational purpose, and the wording of the bill is linked to that rational purpose. The next theme was whether without compensation should be used as opposed to compensation where the amount payable is nil. The BMF and the BLF felt that the amendment bill deviated from the original resolution by Parliament, which spoke to without compensation. The BLF went as far as saying that the bill has a massive fraud and that the committee is complicit in the betrayal of people's desire for land. He suggested, the speaker suggested, to remove the whole of and include all land in the hands of white people as stolen property, and the objective of expropriation without compensation is to return land to black people which was stolen. TASAC, the Council for Advancement of SA Constitution, argued that the compensation that should be either nil rand or a limited value of land under limited situation. I think it was Mr. Naidu who, from TASAC, who argued that a further more effective way to achieve land reform was to combine compensation in limited circumstances with the limited compensation in other circumstances. The National House of Traditional Leaders argued to remove the whole of Section 25(3), which speaks to the amount of compensation payment. As Sipho Mahlangu argued, land was originally dispossessed from its rightful owners, so why should we pay? Our response is, regarding the words nil compensation, in general, a committee will apply its mind to a resolution. If unacceptable consequences, such as a risk of the basic structure doctrine, arise, a committee may then make a decision to better word a bill. Removing subsections 1 to 3 affects the basic structure and would, in any likelihood, be found unconstitutional. With regard to the BLF's suggestion that regarding the rewording of Section 25, Section 25 applies to all property and not just land. So to amend that would affect all property and thus be even more against the basic structure doctrine, as not all property is subject to the history and circumstances around land reform. We would need to consider the effect carefully when amending or deleting this section. TASAC suggested to include compensation where the amount is nil and not limited amount is a policy decision. So it's not a legal decision, it's a policy decision at the end of the day. Not using the phrase without compensation is a result of a legal technical argument, but the wording of the bill to provide for compensation where the amount may be nil achieves the same purpose, i.e. there is no money, no exchanging of money. And we cannot remove Section 3 as suggested by the National House of Traditional Leaders. As Section 25 is for all property, compensation is linked to expropriation in general. Compensation issues are not only linked to land expropriation for land default. Further, this bill is providing the solution for what the National House of Traditional Leaders raised as a concern. Whether to remove improvements in the amendments. The committee is aware that the draft bill states that land and its improvements will be expropriated. The South African Catholic Bishops' Conference, Mike Portier, argued that only unimproved land was taken and that moral clarity that exists when expropriating land with an amount of nil rand for compensation does not exist with regards to improvements. The Banking Association of South Africa, Bongi Kunene, argued that arbitrary deprivation of property should not be allowed and land and improvements needs to be explicitly stated. Improvements should be compensated, which have not been paid by the state. Our response is that originally land and improvements was not an explicit part of the resolution. Rather, it was developed through a workshop held by the committee. It has elicited criticism. It is recommended that improvements be removed, but no advertisement of this would be necessary when amending it. Land will not be arbitrarily deprived, as the criteria in subsection 3 will still be applicable when an offer is made and whether a court decides, and therefore the improvements to the land will be factored in. The role of the courts. There have been two schools of thought emerged throughout oral presentations. One, the courts play a central role as decision makers. And two, the courts are not the decision maker. The SA Catholic Bishops' Conference argued that involving the courts would promote less appeals and reviews. TASAC reminded the committee that there are two separate acts. One, the decision to expropriate, and 2, the decision to determine the amount of compensation, including whether it should be nil, which is then, in their opinion, done by the judiciary. Ndufundo Kwazi emphasized that the courts are overseers and that it would be problematic to give the role to the executive. Members will recall Ms. Shandu pointed out that land reform is a long-term goal and not a political project that could be changed at any whim of whichever political party would be in power. The BMF agreed that courts should not be the decision makers, but rather suggested that a committee decide as opposed to the minister. The Banking Association of South Africa stressed that the courts were prohibitive because of costs. The Legal Resource Centre, Mrs. Wickham, argued that the decision to expropriate is an administrative decision and the courts would slow the process down. The SA Research Chair in Property Law maintained that the courts are reviewers of administrative decisions and suggested that we remove a court may from the current reading of the bill. Our response is, the bill as it stands at the moment currently reads that subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by the effect or decided or approved by a court. The red underlining is our amendment. And then we've also added a new 3A, and that is what we stated. So as members can see, we have factored that where a court may determine. So we agree, a court should not be the only party to decide on the amount of compensation, as that this will result in an administrative burden and delays. With regard to the suggestion by the BMF to limit the power of the minister is in practice not the only role player in making the decision, and a committee may delay matters, but this is, as I said, a policy decision. The courts, as the initial decision makers, could place a heavy burden on the courts and delay resolution. The state is the initial decision maker, and the courts act as a safety valve where the expropriation and the compensation can be challenged. The executive has a role to play and should be able to offer and negotiate for the amount of compensation to be nil. If there's no agreement between the executive and the person affected, the court can then step in, as is the case with expropriation currently. Hence, we propose that the amendment to section 2B and 3A be done. Should circumstances be included? Presenters had the following to say. The Freedom of Religion SA argued that there should be an exception in relation to land use for religious purposes. The presenter suggested that it should read, with the exception of land that is owned and used in connection with the exercise of the constitutional right to religious freedoms. The National House of Traditional Leaders suggested that an exception should be made to land owned by traditional communities, and that this land should not be expropriated. Ndufundo Kwazi felt that it was difficult to comment as the amendment did not list circumstances when expropriation without compensation would be allowed, yet the expropriation bill set this out. They stressed that they would need to know under what circumstances will expropriation without compensation happen in order to comment fully. However, the Legal Resource Centre and the SA's Research Chair in Property argued that circumstances should only be kept to national legislation and the Constitution is only a framework. We respond that the Constitution is a framework legislation and requires a number of acts of Parliament to flesh out the concepts contained in the Constitution. To include exceptions will require instructions. It is, at the end of the day, a policy decision whether to include circumstances and exceptions to exclude subsection 3A as a whole or to retain it as it is. The expropriation bill will include circumstances in any event. One of the other factors that was raised was that the amendment breaches international law. Agri-SA argued that Section 25 is a fundamental right protected by international law, and that the 18th Amendment Bill scraps the equality principle. AfriForum also argued that the amendment breaches international law. Our response is that international principles are being applied regarding adequate and effective compensation. We have presented to the committee an extensive response to the various international treaties, obligations, and resolutions. This research can be made available to members if requested. The amendment and the expropriation bill. This is the 9th theme that has been raised during oral presentations. And once we've unpacked this, I will then briefly present to the committee a brief discussion relating to the suggested wording by various oral presenters. Both the SA Property Owners Association and the Catholic Bishops' Conference raised concern that the amendment is not aligned to the expropriation bill. Our response is, the expropriation bill allows for expropriation in instances of public interest and provides for expropriation where the amount of compensation is nil in cases of land reform. Clause 12.3 of the expropriation bill provides that it may be just and equitable for nil compensation to be paid where land is expropriated in public interest, having regard to all relevant circumstances, including but not limited to. The text of the expropriation bill is as proposed on introduction and is not yet final. The relevant committee is still consulting on the bill and must then deliberate on the appropriate wording of the bill. As the Constitution stands now, it is valid and legal wording. The bill is urgent, as this is a vehicle, and when I say bill, I mean this bill, the 18th Constitutional Amendment. It is a vehicle to implement expropriation where compensation will be nil. And as Section 25 allows for nil compensation, the bill can proceed. However, the wording of the expropriation bill can still be adjusted to be aligned with our amendment. Whether the amendment should, in regards to expropriation where the amount of compensation is nil, have a broad approach, i.e. public interest, or have a narrow approach, i.e. only land reform, is as per the mandate of the committee and is, at the end of the day, a policy decision. This brings us to the end of the discussion relating to the legal points raised by the submitters, honourable members. And I'd like to, as I said, briefly discuss the suggested wording that has been raised in oral presentations. I'd also like to refer to members to Annexure A, which has been circulated to all members. This is this includes both the written submissions as well as the oral presentations regarding to various suggested wording that should amend our current amendment. But we've also responded in writing to the various suggestions. This is a brief summary of the oral submissions. The SA Property Owners Association said that the amendment provides that the powers of the court in deciding on compensation where the amount may be nil is subject to national legislation. But the powers of the court should not only be circumscribed by national legislation, but also the Constitution itself. In the current amendment, the courts are not circumscribed to the Constitution. The BMF proposed an entirely new process. Compensation for any significant structures provides for ownership of land. If you have an uninterrupted occupation, it should be backdated 1913 should be backdated to 1652. Black Land First proposed that the amendment should allow for confiscation of all land in the hands of white people without compensation and given to Black people who embrace Black consciousness. The National House of Traditional Leaders said that we should protect communal ownership of land, that it should be for public purpose, and public purpose should include communal ownership of traditional land. And they also suggested that the community interest be public interest. Remove any reference to compensation and remove 1913. The SA Research Chair in Property Law argued that to remove a court may determine. And I explained the reason why they had suggested that earlier. Our response is that in terms of South African Property Owners Association suggested to amend the Constitution to allow for the powers of the court is also circumscribed in the Constitution. We would like to point out that it's already there, that the case as our current amendments to subsection 3 links to subsection 2B. So the court's power is circumscribed by the Constitution. To add wording that the court should always decide on the amount of compensation as suggested by some presenters is a policy decision. Black Management Forum suggested that a sort of blanket approach to expropriation with no compensation. But this blanket approach, we highlight Mike Campbell, which held that the access to courts is enshrined in international human rights treaties. The Zimbabwean amendment specifically prevents any person from seeking a review from the court, which is totally different to what our amendment does. In this case, the court held that access to courts is enshrined in international human rights treaties. The court further held that the Zimbabwean amendment specifically prevented any person from seeking review from the courts. The Zimbabwean amendment provided for a blanket type of expropriation without compensation, which was suggested by the Black Management Forum, therefore ignoring circumstances of each case and removing discretion. This could be argued as being against the rule of law and the principle of substantive legality. To oust 1, 2, and 3 and replace them with the proposal as suggested by BLF would change the basic structure of the Constitution. Public interest includes community interest. This is in fact included in proposed national legislation. Furthermore, public interest is a wide concept, and I explain it there. The expropriation bill uses the term public interest, which includes the nation's commitment to land reform and to the reforms to bring about equitable access to all of South Africa's natural resources. The community's welfare and the equitable treatment or redressing the injustice in regards to that community thus falls in public interest. That phrase is accordingly used for expropriation of land reform. And finally, any adjustment to the date in subsection 7 is a policy decision and will require the committee to request permission from the NA and to further advertise. Thank you for your patience, members. If there are any questions, myself and Advocate van Heerden are here to answer.
Advocate Haley, thank you very much for a clear presentation. Honorable members, we shall agree that we can only take questions of clarity and nothing more. Honorable Suma and Honorable Dr. Melda.
Thank you very much, Chair. Let's appreciate and okay your words in terms of our legal services. The very good, well thought work that they've put. It will assist us moving forward. And equally also appreciate the Minister opportunistic on this one, that she didn't only confine on our role, but she went and extend in terms of responding to some of the questions which are oversight role, as it were, but just appreciating that. 2, Chair. 3 is that I'm seeking guidance here. My understanding is that we haven't received a presentation from Public Works for whatever reasons. If I can be empowered, when are we going to meet them? Because I'm worried about the time, because we should have concluded this process last week. So it does create a problem. Thank you very much, Chair.
Thank you. Honorable Hon.
Yes, thank you, Chair. I just want clarity on the statement that the amendment itself does not constitute a limitation of the right, and ask of legal services, how do they, can they explain that a bit further, specifically in light of the the wording of Section 7 of the Bill of Rights and the last section of Section 7. Thank you.
Okay, Honorable Dr. Mulder.
Thank you, Chairperson. Thank you for the presentation. I have one question of clarity and then one request. The presenter referred to the basic structure doctrine, and I would like to ask, how can land reform be seen as a narrow, exclusive endeavor? And I specifically referred to subsection 25.8 because subsection 25.8 goes beyond land reform. It also refers to water and related reform. It's not only land reform. And subsection 25.8 is also directly linked to section 36.1, limitation of rights. It's not in isolation. So that's just a question. The request I would please ask, the offer was made to provide us with the international research, and I would please ask to have a copy of that. Thank you, sir.
Thank you, Dr. Honorable Shivambu.
No, thanks, Chair. I'm detecting very problematic notions from these legal office presentations because it's beginning to even suggest that there are certain amendments that we cannot change because that would be unconstitutional. I don't think that is a proper constitutional interpretation. If we follow proper process, we are permitted as members of parliament, as the National Assembly, to change the constitution. There's nothing cast on stone in that constitution. There is a clear process that if majority of parliament, if 2/3 in some instances plus 6 provinces, agree on an amendment of the constitution, we can change the constitution. So if we are not permitted to do that, then that is dictatorship, where even the majority is disallowed to change the constitution. That is problematic in terms of the first observation that I'm making. But two, it appears that we in this framework which we are deliberating on now, we can't effect changes in other sections that are not in that 18th bill which was published. That is problematic because, for instance, the minister has illustrated with evidence now that subsection 3 is problematic because it says that prior to expropriation, you must look into the history of acquisition of the land. And majority of these occupiers of the colonial settlers that are on the land now have not acquired any land. They are inheritors of stolen land by colonialism of an apartheid.
No, that's untrue.
And the constitution in terms of what happens. I'm still speaking, Chief. Can you please shut up?
No, I won't.
No,
no, you will. You will shut up. Nobody interrupt you.
No.
Nobody interrupt you.
Honorable members.
You will shut up and respect this process.
Honorable members, there's only one chair who can make rulings. Please, Honorable Shivambu is duly recognized to speak his mind, and he must not be impeded.
Thank you, Chair. Because also, we can't, it will be a futile exercise if we conclude this process without having effected any change on subsection 7, which speaks about the 19th of June, 1913. So to then suggest that what we are busy with now will not have an impact on all the subsections, then it's problematic. Then we're in pursuit of a wrong process altogether, because when we tabled the motion, it must go and read the motion that we tabled and was adopted by Parliament. The first time the Constitutional Review Committee was established, it said that we must, of course, engage in process of consultation, but then we must also look into the issue of land tenure. That is what the resolution says. If you look into it, Chair, you will remember that is what it said. So if currently we've got limitations in terms of what we have to deal with in the comprehensive amendment of Section 25, then this process has been hijacked by the legal office and rerouted to achieve something else other than what we are busy with now. And that is entirely problematic. We are amending Section 25 of the Constitution so that we can permit the state to repossess our land without compensation. That is what Parliament has agreed. And any attempt to use technical basis to reroute this process
is entirely reactionary, problematic, and it must be investigated as to where does it come from, because all these submissions that we have made, all our phrasing that we said the constitution must look like has been submitted. It's in the final report. Why is it not finding expression in the actual textual amendment of the constitution itself? I think the legal office is an infiltration of this process and must be rejected. We amend the constitution and move forward.
Colleagues, my apology. I've just seen the chair have locked off. I think the system have kicked him out. Ordinarily, then there are hands here. Then the administration can assist to move forward so that we can take other hands, because there are other hands here. But just to assist us to wait for the chair to be logged in back to the meeting.
Chairperson.
No, Honorable Ronnie, let's give a few minutes for the administration to get the chair back, because I've just indicated that the system have kicked him out.
I thought you were chairing.
Let's allow that few minutes first before we do that.
Okay.
Any like Advocate Romani and Advocate Kwebe with the chair.
Good morning, members. I've just spoken to the chair and it's time to reconnect.
Okay, thank you very much.
Hey.
What's happening? Why is it taking so long?
That is my question also. Maybe it's because some of us have logged in now.
No, let's just keep quiet, Honorable, and just wait. Don't add other unnecessary comments.
It's gone for a caucus.
No.
I see Honorable Murat Setla is here, so who is he caucusing with?
What is your trouble, Ndate Masipa? Honorable Masipa, how are you?
I'm fine, no trouble, sir. And how are you?
I've got trouble.
Go fetch the chairman and lower your hand.
Advocate Bonani and Kwebe, can we have a feedback, please? We can't just be waiting.
The chair is connected.
Oh, there is he now. Thank you.
Hello. Hello, Honorable Imelda Shibambo, you were on the floor. Hello?
He's done, Honorable Chair, is the following speaker, Dr. Muda.
Honorable Swart. Honorable Swart.
I can repeat what I said, Chair, if you did not capture everything that I said. So that you then.
Thank you, Chair.
No,
You've recognized me.
I did. I just wanted to check if you still continuing, but otherwise I did. Honorable Swart.
No, thank you, Chair, and greetings to you. Chair, just at the beginning, I want to say that just because a member might not agree with the legal opinion, one shouldn't cast aspersions such as infiltration and these type of aspects relating to the parliamentary legal services. If you disagree with the opinion that's given, you can obtain another opinion. If the committee is unhappy with the legal opinion, then the committee can agree to obtain another opinion. But I do want to protect the legal services and reject any allegations of infiltration, as Mr. Shivambo just made. I think we need to be very clear on that regard. Chair, my issue I would like to raise is the issue of the role of the courts. And I would like to just ask the legal advisors, there are two issues here relating to the role of the courts. First, the decision to expropriate, and second, the amount of compensation. And there have been various views in this regard. Given the opinion of the legal advisors, does it not impact on Section 34 of the Constitution, which allows access to courts for everyone who has the right for any dispute, which would include an administrative decision to expropriate as well as the amount of compensation? It's very important, and I'm sure we are all in agreement that we need to ensure that any constitutional amendment which we pass is constitutional. The court's decisions that were quoted by the legal advisors make it very clear, and there's grounds for that a constitutional court amendment may in itself be proven unconstitutional if firstly the procedure is not followed, and secondly if there are certain issues that are raised in that. Have a look at those decisions, although it was obiter. I understand that what Honorable Shivambo says in that regard, it is a contentious issue as to whether a constitutional amendment can be found unconstitutional itself. That is raised obiter in certain decisions. Thank you. I think you're muted again, Chair.
Honorable members, I just want to repeat what I said in previous meetings, that if you put 100 lawyers in one room and ask for an opinion on one single matter, you may get 100 opinions. So let's accept those are their opinions and they are entitled to those opinions. But as political parties, we are entitled to consult our own lawyers on these matters. And when we come back to engage, make your presentation based on your own legal opinion. So there's no need to fight over what legal says. That's and then we don't debate of what they are saying. Honorable Murasetla. Honorable Murasetla.
Yes, I can hear, Chairperson, and good morning. You have partially covered me because I wanted to propose. I wanted to clarify the point that we should not fall into the trap of discussing the input from the constitutional legal experts. We still have got our own time where we are going to unpack and discuss this. So this is the point I wanted to drive home, that if we start this debating now, we may not arrive at a conclusion. They have given their view and some of the views are uncomfortable. But I wanted to propose that we pack it, note it, we will see it when we come to our own meeting for discussion. Thank you, Chair.
Thank you, Honorable Rasta. Honorable Suma.
No, Chair, I was covered. I just want to courteously remind you to my first part that because it impacts on what Honorable Murasatla have raised, the issue, when are we going to be meeting Public Works? Because you didn't talk to that one in your opening remarks, Chair. Thank you. Honorable Chair, I'm done. Thank you.
I think I must start co-chairing, you know.
Dr. Njofu, is not going to
how do you chair without being appointed? Who appointed you?
No, I'm saying that I think so. It's not wrong to think, Bantuna. Oh.
I keep on thinking, it's correct. It's just think.
Do you want me to propose your name?
There will be serious order here if I can chair properly. I'm very good.
I will second your proposal, Comrade Ronnie.
Do you want me to propose your name?
Yeah. It's very important. I think it will benefit all of us. You know, it will balance the.
You did not lobby me in advance, Comrade.
Advocate Bonani and Kwebu, can you help us with the GMA tuna, please? And
he's worse today, Comrade Matola.
He mustn't touch
the
he must show his face and also not to mute. He must stay like that.
I propose that Honorable Lesoma chair, in case the chair is collapsed. Any seconder?
The collapse one is very dangerous, ne?
Yeah, but it appears the meeting is going to drag too long because of this.
Advocate Bonani and Kwebu, assist so that we can proceed, probably.
Morning, honorable member. The chair is logging in now.
And advise him not to touch his gadget. He must just let them on both mute and the video so that nothing happens.
Hello. No, it's just a network problem. Honorable Murasatla, you had finished talking. Hello? Hello?
Yes, I've long summarized my input, and after me, it was also Honorable Lesoma who supported me.
Okay, honorable members, thank you very much. I think we agree that the questions now are questions of clarity. And this is to arm us to go back to our principles and seek mandates on different issues that have been raised. And as Honorable Murasatla and Suma are saying, when we come back now to deal with the bill, we'll be informed by our own legal opinions and the legal opinion of parliamentary legal services. So they are not imposing any position. They are lawyers, they are entitled to their legal opinions, and they've done very well. Now it's for us to go back to our principles and seek mandates. Is there any other thing that anyone wants to raise? Honorable members, are you still there?
Yes, Honorable Chair. The only point, Honorable Chair, if I may, is the public works one, because I believe it's critical. Yes, please.
Yes, Advocate Ramano, what was the last communication with Public Works?
Chairperson, the last time I spoke to them, it indicated that they were requesting an extension so that they can adequately prepare. And secondly, they were also raising the fact that the minister would not be available today and tomorrow.
So can we accommodate them sometime next week?
Yeah, we currently we don't have a meeting scheduled for next week. So if that is what the committee wants, then we can arrange with them and seek the necessary permissions from the chief whip.
Honorable members, do you agree that we need to accommodate them? And the fact that we don't have a meeting next week should not be a problem, because we can request permission to meet and everybody will appreciate the urgency of the matter. Honorable Melda, Honorable Rossetta, do you have something to say on that?
Chairperson, no, I'm on a different point, but I don't have a problem if we meet next week to listen to the department, but I have a different point. Thank you.
Okay, Honorable Rossetta.
Sorry, Chairperson, that is an old hand. Let me lower it. Thank you.
Okay, Honorable Shibambo.
Chair, I think we can meet next week. And can I make a plea that because of the vitality of this particular process, can we explore the possibility of having a physical meeting? We can agree either in Gauteng or in Cape Town in terms of the process, so that we do not have these things of the connections and cut-offs and all of those things there. Let us go thoroughly through this process. The country and history and the future is expecting on us to come with a quality outcome. Can we please consider having a physical meeting so that we deliberate openly on all of these issues instead of this arrangement, which is proving to be inadequate in the manner that we're dealing with these issues?
Thank you. We shall consider that and come back to the members. Honorable Melda.
Thank you, Chairperson. Before you were kicked out of the meeting by the technical problems, we were still talking and putting questions on the table for the legal services for clarity, and I'm not sure if they would like to respond, or if you would like to give them an opportunity to respond. They haven't done so. Thank you.
Thank you for that reminder. Advocate Haley.
Okay, good morning. If I may start from legal services in answering some of the questions, and then my colleague Ms. Halisaki will take over. Just to respond to the Honourable Horn in respect of how this amendment is not in itself a limitation of the right. We must keep in mind that we are not dealing with, and this is going to sound strange, we're not dealing with national legislation in the sense that we're dealing with legislation that amends the Constitution and not legislation that flows from the Constitution. So Section 36 is relevant to national legislation. So yes, it is so that Section 7 sub 3 indicate that the rights in the Bill of Rights are subject to the limitations contained or referred to in Section 36. But a number of the rights in Chapter 2 have their own limitations entrenched in them, their own, not necessarily limitations as such, but even requirements and criteria. So when we say that this bill is not affecting Section 36 and therefore also not Section 2, what we mean is that this bill is simply taking what was raised as a concern, namely that there is no clarity on whether an offer can be made by the executive or a decision made by the court in the amount of R0 when property is expropriated. So this bill is not changing the Constitution's content in that way, and therefore it is further not national legislation, and therefore Section 36 does not come into play. My colleague will say a little bit more on the basic structure doctrine, because that is something that we must keep in mind when we are amending the Constitution and when we're bringing in further criteria into Chapter 2. If I may then, just in respect of the Honourable Shivambo, I'm not going, as was said later on, it is for this committee to debate and consider our advice, and the committee will make up its own mind as to what it accepts and does not accept. It is in the end the committee's decision. But it is necessary for us, as in a supporting function to this committee, to highlight to this committee where it can see wrong, so that if this bill is passed by this committee, passed by the NCOP and assented to by the President, and is then taken to the Constitutional Court with a concern about its constitutionality, that we can say, according to our advice, we help this committee to pass a bill that will succeed in will pass constitutional muster. So when we say that certain amendments are not possible, yes, we agree that if you follow the process, then you have a constitutional amendment. But there is also a doctrine, and we would be amiss if we do not bring that to the attention of the members. If this committee does not consider the basic structure doctrine, there is a risk that this bill, once enacted, may be declared unconstitutional, and that we do not want. The committee can consider the basic structure doctrine and can say, we don't think it's applicable, we don't think it applies to South African law, and then move on from there. But it has to be considered. In respect of amending other subsections, we're not procedural experts in Parliament, and we will have to also consult the National Assembly table staff. But in our view, when we look at the resolution that was taken by the House when this committee was established, we must keep in mind that the resolution was based on the report of the Constitutional Review Committee. And the House indicated that the Constitutional Review Committee recommended that Parliament amend Section 25 of the Constitution to make explicit that which is implicit in the Constitution with regards to expropriation of land without compensation as a legitimate option for land reform, so as to address the historic wrongs caused by the arbitrary disposition of land, and in so doing ensure equitable access to land and further empower the majority of South Africans to be productive participants in ownership, food security, and agricultural reform programs. So when we advise the committee, we need to keep that in mind. That is the restriction that we need to put to the committee. It doesn't mean that this committee, and that was presented as well, when we presented on whether the committee exceeded its mandate. For us, that resolution encapsulates the mandate of this committee. And it doesn't mean that the committee cannot say, we do want to amend other subsections that do not deal with this compensation issue and the amount being nil when it is for land reform. The committee can go broader, but what we are saying is that in our view, the committee will have to approach the House and extend the mandate of the committee before it proceeds with those amendments. If I can then also speak to the role of courts and Section 34, mentioned by Honourable Swart. In fact, yes, absolutely, we agree. And that is one of the things that we need to be very cautious about. But our proposed amendment does not remove the courts from this process at all. If we look at Section 25, the amendment that we do to Section 2B indicates it is property may be expropriated only in terms of a law of general application, and then paragraph B, subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. So already that remains in the Constitution. So we acknowledge a role of the courts. Then our amendment comes and we say, provided that, and it goes on. And the problem that just arose, that by including the words a court in our proviso, it is now being interpreted that it is only a court that can decide on nil compensation in the case of expropriation of land. And that was not the instruction, that was not the resolution, that's not the mandate of this committee in our understanding. So no, the role of courts is retained. It is just that we propose an amendment to the addition to subsection 2, paragraph B, in order to remove that misinterpretation of that section. And then, if I could maybe ask then, yes, I think those are the ones that I said I would answer. If I can maybe then ask Ms. Heidi Starkey just to speak to the question of the basic structure doctrine, please.
Thank you, Advocate van der Merwe. I will, Honourable Mulder, I will definitely circulate the research regarding the international law issues to all members. I don't believe I was clear enough when I was explaining the basic structure doctrine, and I do apologise for that. Land reform was the mandate of the committee, so our amendment therefore reflects that. The amendment is not does not affect subsection 8. So subsection 8 envisaged national legislative measures. Our amendment is narrow and not wide, and it reflects, as I said, the committee's mandate. Therefore, we don't believe that it impedes the basic structure doctrine. This is not a radical and fundamental restructuring of the Constitution. We are not bringing in any new features. We are making clear what is there already, and I hope that answers the question.
Thank you.
Yeah, and I think that was.
Thank you, honourable members. I think we have met the purpose of this meeting. We wanted a briefing from the honourable member, minister, which was done. We wanted a briefing by legal services, which was done. And I think all the presentations were clear, regardless of what we may think about them. That's a separate issue. Now, I think that we need to now move forward. I propose in the following manner, that Honorable Kaba has addressed us on the scope of our mandate. And I requested that he puts that in writing, we circulate it, because in the future meetings, we don't want to exceed our mandate, and we want to ensure that everybody acts within that mandate. Secondly, the input by the minister is available. The input by Advocate Ramasala is available. Now we are agreeing that we will find a date next week for the presentation briefing by Public Works, and then we will advise you of the date. But what I want to propose is that the minutes of all the meetings should be finalized, and at that meeting with Public Works, we must adopt the minutes, and also the revised report must be presented, because if there are no minutes, then our communication may be based on something that we have not agreed. But if we have minutes, when the chair writes a letter or the administration drafts a letter, then we will check the correctness or otherwise of that letter or communications against the minutes. So I want to appeal to the administration, finalize all the minutes so that we adopt them next week when we meet, and equally finalize the report on public participation. And I want to remind members that we asked Honorable Kaba to assist the administration at their requests in finalizing the revised report. So I don't want in future somebody to be asking, where did Honorable Kaba get the mandate? He got the mandate from this committee, and he must take that mandate to its final conclusion by helping the administration to bring the final report. And then in the intervening period, I think we all have an opportunity to go back to our principles, to seek mandates on various policy and legal issues. Because from here, after Public Works, we are now going to deal with the text of the bill so that we finalize it on time without excuses. So, and the report on international matters, we agree it must also be circulated. Is there anyone who has comments on what I have said? I don't, Honorable Suma.
Let me just formalize that we agree with your summary, Honorable Chair. Thank you very much.
Thank you, Honorable Dr. Melda.
Thank you, Chairperson. I hear what you're saying. I just want to ask one question. If the Honorable Kaba has now phrased his perception of the mandate, are we bound by that? Will we discuss that? It may be that we differ in terms of his interpretation. How do you plan to deal with that? I just need clarity. Thank you.
No, we will circulate it because that mandate must be owned by all of us, and I think we will ask him to do it. We circulate it so that all members of this committee can read from the same page and sing from the same hymn book. So Honorable Kaba is discharging a mandate from us. He's not dictating anything from us, but as I said, he has an institutional memory because he has been working with the administration and he has been doing very well. So that's all we're saying. And having said that, honorable members, I want to thank you for your participation in constructive contributions, and the meeting is adjourned.
Inkosi, Chair.